Um, so I'd like to read just a little bit about Jeffrey. And I know Jeffrey because I work in another organization with him. So Jeffrey is an accomplished composer, lyricist, vocalist, pianist, guitarist, and bass player with a Bachelor of Music and Composition from Berklee School of Music and a Master of Music and Composition from the University of Edinburgh. He has composed everything from pop songs and jingles to symphonic chamber and choral works, but his passion is composing musical theater. Jeff is also a veteran entertainment attorney, earning his JD from Seattle University School of Law in 1993. In his 25-plus year legal career, he has represented songwriters, performers, independent record companies, authors, and filmmakers, worked as in-house counsel for independent film production companies and multimedia organizations, and taught entertainment and music law at the university and law school levels. He is currently Mike Kerb Endowed Chair of Music Industry Studies at California State University at Northridge. Jeff is admitted to practice in the states of New York, Massachusetts, and Washington, and proud to be an ASCAP affiliate, as well as a member of the California Copyright Conference, the Recording Academy, College Music Society, the Society of Composers and Lyricists, International Association for the Study of Popular Music, Association for Popular Music Education, Songwriters of North America, and the Music and AMP, or it says Music and Industry Educators Association. Whew, that was a mouthful. Welcome, Jeffrey. Thank you for being here on.
Thank you for having me. I'm sorry I sent you. Sorry I sent you the extended bio.
That's okay. No worries.
That takes care of the entire presentation. So I'll see you later. Okay. So anyway, thanks for having me, and it's a pleasure to be here again, Margarita. I know through another organization we work with, and so I'm going to jump right into it. She gave you the whole spiel about my wonderful background. It sounds even better than did I really do all that stuff? I don't know, but this says I did. So, so I have a presentation. I don't know if I have the ability to share my screen. If you can do that, that'd be great, because I have a little Facebook presentation and a lot of stuff on this. But what I'm going to do is just kind of breeze through the high points, and I want to make sure I leave time for questions at the end, about 15 or 20 minutes. So anyway, so without further ado, as they say, where am I? So let's see if I can share my screen. Looks like I can. Yay. So since I have all that neato background as a musician and an entertainment lawyer, I wanted to do a presentation today about copyright, especially in the classroom, because I know that's a big issue. I was speaking to Margarita and Mariah, and it always comes up. You know, if you're teaching young students or older students, either in the classroom or private lessons, it inevitably comes up. And one of the things that comes up most often is something we call fair use, which you probably have heard of. So I'm just going to go bang right into it now, and thank you, Sandra. It's Scotland. I used to live over there when I went to the University of Edinburgh. That was my neighborhood, so I'm very proud to say. So let's see, let's go to the slideshow. Okay, so as you can see, a snappy title: All is Fair in Love and War, but not copyright. So I'm going to start off with just a few, basic copyright concepts, and then, morph into the fair use discussion. Oops, sorry. So the big question is, when is something copyrighted? Now, I know, is everybody here pretty much do you work in the classroom, or do you work, private lessons, or both, or what's everybody's jam here, as the young kids say?
I think most
of for me. But,
is that private lessons?
Yep.
Okay. Well, this is still very relevant, because I'm sure you have students that are working on projects, and maybe you are as well. So this is also good for the grown-ups in the room as well. This first sentence here is what I tell my students is the most important sentence in the copyright law. When is something copyrighted? Well, as soon as you fix it, if it's original, an original work of authorship fixed in a tangible medium of expression. So it has to be original, has to be an expression, and it has to be fixed. So for instance, this week when I was preparing this PowerPoint, as soon as I wrote it down, I put it into my computer, it was copyrighted. If you're recording a song, and as soon as you put it down on your either on your iPhone, on your computer, if anybody still uses tape machines, it's copyrighted. Now, there is the issue of whether you need to register that copyright, and the conflicting answer is no, you don't have protection, but yes, you do if you want to sue somebody for infringement. Again, I'm going to breeze through this. So, if you want to put some questions in the chat, I'm going to keep an eye on that. So maybe if it's something that you don't want to wait to the end, that's totally cool. So originality doesn't mean novel or never seen before. Patents, for instance, to get a valid patent, it has to be a new invention, a new formula, something, something that has never been devised before, the better mousetrap, right? In the copyright law, original really means just not copied from someone else. Now that carries a lot of weight, like everything in the law. That doesn't mean that you're sitting in a classroom, peering over your classmate's shoulder and copying down what they're writing. There's ways to determine, which we're not going to go in here because that would be another there'd be a whole nother, at least one other presentation. So, but just for now, and we can, expound on this later if you want. As long as it's not copied from something else and it's been independently created, then that means it's original. You cannot copy facts and data. So if you want to just, put down like recipe amounts just in any random order, well, that's not necessarily, those are facts. That's data. Those are teaspoons, tablespoons, and stuff like that. When you start arranging that data and those facts in certain order, which kind of suggests some level, a very minimal level of originality, then you could possibly copyright them. Now, if that wasn't the case, nobody would be making money from cookbooks. It's how the facts and data are arranged and what level of originality is introduced into them. I just talked about the registration office. Registration with the Copyright Office is not required. It's very easy to do it. I can explain at the end of this during our question period. It's extremely easy. Everything's online now. They walk you through it. It's extremely easy and highly recommend it. Best $55 you'll spend on a piece of music. Very important here that, again, some of this stuff I'm going to be exploding a few myths, I think. So everybody, and again, if you know this stuff, just raise your hand and let me know. Say, you've heard this before from somebody, but I'm just going to kind of talk to I'm going to pretend that a lot of this stuff, which is kind of complicated and nuanced, it might be new to a lot of you. But one of the things I always get, especially when we're talking about YouTube, which we're going to talk about at the end of this, that's like the last slide on this thing, which I'm going to be sharing. We'll be sharing with you after this. Well, I didn't, I get students say, well, I'm putting it on YouTube and I'm using it, but I'm not making any money from it. Well, that doesn't mean anything. Copyright infringement is copyright infringement, whether you give something away for free that you use without permission, or you're making money from it. It has nothing to do with the liability of whether you're infringing on someone's copyright or not. It does come into play if you get sued and you lose and you have to pay damages, then the intent and whether you're making money does come into play to determine that. But as far as the copyright infringement goes, doesn't make a difference if you're running off 100 Taylor Swift CDs and giving them out to your classmates or something, or your students or your family at the next holiday dinner. It's still infringement. This is some of the stuff I'm going to say today is kind of scary, so please bear with me. It's not that scary. This is just the state of the law. So come on, go. What are you doing? There we go. So you can read this when you get this PowerPoint. These are the works that can be copyrighted. So it's just a litany of, there's 8 categories basically. This isn't necessarily exhaustive. The wording is copyright, extends to original works of authorship, including these, so in case they want to add to it later on. The only thing I would call your attention to is number 2 here, musical works, and including any accompanying words, so songs with lyrics, and sound recordings. Now we're going to talk about that in like the 2 slides from now, because they do make that distinction between the song and the sound recording. So hold off on that for a minute. And if I'm going too fast, please let me know, and I'll slow down a little bit. Okay. And finally, in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, et cetera, et cetera, et cetera. Okay. So if I go to Steven Spielberg and pitch an idea that says, okay, well, I've got this idea of dinosaurs being cloned, and that's my idea. Well, that's not copyrightable. However, if I go to Steven Spielberg and say, I've got this idea for, dinosaurs being cloned from, DNA found in mosquitoes encased in amber from the Jurassic period, and a mad scientist puts them in a park on a deserted island. Well, you're getting closer and closer to an expression of an original, expression of original authorship. It's not just an idea. You're fleshing it out with detail, which is sort of one of the, indicia of whether something is original enough to be copyrighted. I'm sorry I'm going so fast, but I just want to go through at least. I'd rather go fast and leave room for questions. Okay, so, this is the other one. So again, I won't go all through this, but this basically gives you a rundown of what a copyright owner in a original work of authorship has the power to do. Okay, so to reproduce the copyrighted work, to prepare derivative works, to distribute copies of phonorecords. So again, you can read through this. I'd rather not take up the time, or we can come back to it, just because the fair use thing is really what I want to get to if we can today. Another thing that is going to be related to the very next thing I talk about is the distinction between copies and phonorecords. And that is related to what I've already mentioned about the difference between the song and the sound recording. So let's talk about that, because if the most important sentence in the copyright law is that original work of authorship fixed in a tangible medium of expression. By the way, that means if it's an oral expression, you can't copyright it. It has to be somehow fixed, either written, recorded, or in some fashion where someone can read it or listen to it or, view it on a screen. So if that's the most important sentence that I tell my students in the copyright law, this is the most important concept for musicians. All right. And this is probably, for some reason, I'm not saying that, in a condescending tone, but it's because it is kind of a hard concept, but it's the most elusive concept I found that, in my, years of teaching copyright law. This is the most elusive concept for some reason that students and even, professionals I've dealt with have a hard time, getting a handle on. So when you buy a CD, I can tell how old I am. I could say vinyl records too. They really know how old I am. When you buy a CD, when you buy a record, when you stream something over Spotify or Pandora, when you're downloading something from, people still download stuff from iTunes, I guess. I just did the other night, actually. I didn't think you could do it anymore. When you download or when you stream or when you buy a fixed, a musical composition fixed in a tangible medium of expression, there are 2 copyrights involved. There's the copyright in the song itself, and there's the copyright in the sound recording, in the record, in the phonorecord, which is the reason why they separate copies from phonorecords, because regular copies like sheet music or books, literary works, the medium in which they are, expressed or fixed do not carry their own set of copyright copyrights. But phono records or sound recordings, they have a lot of weird, um, verbiage in the copyright law because it's, it was concocted by a bunch of lawyers, and we like to make sure that we get paid so we can, have people, we can interpret this, this arcane language for people. So that's what keeps everybody in business. Not really, but there's a separate copyright in the sound recording. So the copyright law defines that as works that result from the fixation of a series of musical, spoken, or other sounds, but not including the sounds accompanying a motion picture or other audiovisual work. We're going to forget about that for now because that comes up, that does suggest its own extended, tangential discussion. Regardless of the nature of the material objects, such as disc tapes or other phone records, which they are embodied. So the best way to envision this is either you're thinking about putting a song in a film, or what I often do is to wow my students with older technology. Some of us here may remember when ringtones first, when cell phones first became very popular, like they say in the 90s, okay, early 90s maybe. And it's, if you wanted something besides the typical standard tones, you can go to a website or go to your carrier and you can download, I don't know, let's say Let It Be by the Beatles as a ringtone. But if anybody remembers those days or has a relative that has an old phone from like the 90s, that song, Let It Be, would be some monophonic, horrible sounding, cheap thing, that you wouldn't want to ever play in public. But that was the best it got in those days because of the technology. All right. So whenever you downloaded the copy of Let It Be with that monophonic, very basic tone, Lennon and McCartney got paid a royalty for that. It's called a mechanical royalty because you're embodying the song in a mechanical format. Fast forward to 2021, where now if you want Let It Be, assuming there's the correct licenses are in place, you can actually buy the Beatles version or download the Beatles version to your phone where they're singing Let It Be. I have a couple of Beatles songs on my phone. When you do that, not only are Lennon and McCartney, in the case of Let It Be, getting a royalty, but now the Beatles as recording artists are getting a royalty because, which brings me to, the related concept here is that royalties that emanate from or generated by the use of the song go to the songwriters or the publishers, whoever owns the song copyright. Royalties that are generated or emanate from use of the sound recording, the record, or what have you, go to the recording artist or the record label, whoever owns the copyright in the sound recordings. So I'll give a couple other examples here. Well, before I get to the free falling one here, because this is a really hot area when you use music and film. You think of Tony Bennett. Tony Bennett is a recording artist. He'll record a song, a whole album of Cole Porter tunes, or Gershwin, or name the classic American songbook composer and lyricist. Now, when he does that, and people go in and they download his CD, or they go into Barnes and Noble, where you can still buy CDs, and you buy Tony Bennett Sings, the Great American Songbook. Well, the estates of those classic songwriters are going to get a royalty for having their songs, included on that CD. Tony Bennett, on the other hand, will get his money from sales of the physical records or the downloads. We'll just stick to physical records for now. And it's kind of a weird thing because, and this is where I think why it's a little hard for young people, especially, to kind of get a grasp of this. You're selling one CD, but there's several different parties, several different royalties that are flowing from the purchase of that CD. That's because there are two separate copyrights. I give another example here. If you're making a film, and let's say you want to use Tom Petty's "Free Fallin'" in the film, his famous song, his recording, you need two permissions. You need the one from the copyright owner of the song, particularly the publisher, and one from the recordings copyright owner, typically the record label. So when you are negotiating with these parties to put Tom Petty's Free Fallin', or pick any song, you have to you have to negotiate for those two separate licenses. Okay, is everybody with me so far? I don't want to say too much. We're gonna go into fair use in a minute. Now, the big thing about one of the big differences between songs and sound recordings is this last item here. The copyright law says expressly, with no holds barred, that if you have permission from the song's copyright owner, like say, let's go to Free Fallin', you want to use it in a film, and Petty's publisher has given you've paid him like 500 grand or whatever they're going to demand for that hit song to be used in your movie. But his record label will not budge. They said, no, we don't want Tom Petty's, in your movie. It's an action movie. He's above that or whatever, who knows? His estate at this point, obviously. Well, you can go in and record an exact replica of Petty's song without copyright infringement liability or any danger of incurring such liability. That's a big difference between if you did that, you couldn't do the same with the song. You can't do, okay, well, I don't have permission from Petty's publisher, so I'm going to go in and just like write my own Free Fallin' and use that because I'll just like, I won't copy it. I'll just like I'll write different lyrics. Well, you can't do that. And that's a huge distinction. Now, again, we can, it probably brings up more questions than, the answers right here. So just make note of what is still unclear, or please interrupt me. You can do that either in the text or raise your hand or something like that, even though I don't have everybody on screen here. Any questions so far about any of this stuff? We might as well have a little question break here. Can you repeat the last thing? Okay. Yeah. Oh, this is what Taylor Swift is doing. Yeah, we'll talk about Taylor Swift in a bit because she's been in the news about her records and stuff like that. Yeah, I'm Margarita. You have you're asking it to me, but maybe you should ask it to everybody.
Oh, sorry about that.
Oh, it's okay.
I just wondered if you could repeat. So you're saying that if you have one copyright owner says you have permission for their part, but you still have to get permission from the other half.
Okay, if you have the song's copyright permission, the song copyright owner's permission, you can make your own recording of that song without asking permission.
Okay.
From the record label.
But you can't do anything with the already made sound recording. I mean,
unless they give you permission to do so. So again, if you're putting, I don't know if you've seen the Pulp Fiction, and most people have at this point, I think. There's a scene where John Travolta's picking up Uma Thurman at her apartment, and she clicks on the tape, and it's the Neil Diamond song, "Girl, You'll Be a Woman Tonight," right? I don't know if you remember that scene. Well, that's not Neil Diamond singing it. That's someone else singing it. It sounds very much like Neil Diamond. It's the same arrangement and stuff like that. But my guess is that when Quentin Tarantino was making the film, he couldn't get Neil Diamond's record label on board to license the recording, but he did convince the publishers to let him use the song. So he went in and recorded a song that sounds eerily similar to Neil Diamond's recording, and that's perfectly legal. But you can't do the opposite. You can't get the permission from the copyright in the sound recording copyright owner. I say, we got that, so we're just going to go record our own version of the song for this movie. You can't. It doesn't work the other way. It only works permission for the song, duplicating the sound recording. You can't get permission for the sound recording and then duplicate the song without permission. Okay, does that make sense? Did that clear that up a little bit?
Yes, thank you.
Okay, just you always remember that difference between the song and the sound recording. Two totally separate copyrights, obviously intertwined and related, but they exist on two separate levels. And so if you're using anything like that, now this has a lot to do with, for instance, when your students might be recording cover tunes, there's another whole thing that we're not going to get to today about recording cover tunes. But because you're in education, I really did want to talk about fair use. Now, fair use, you might have, heard the term before. It's basically an exception to the permission requirement. So if you're claiming fair use, you're essentially saying, as it says here, or you're essentially saying you could use the stuff, but you don't need to seek permission. So this has been litigated, appealed for 100 years. And we're not going to go into the nuances and the way things have been, litigated over the years. But if you ever want to look up a great case, I was going to quote it here, but I wanted to stay away from getting too thick with the case law and all this crap. So anyway, the rap group in the, I'm gonna say in the 90s, recorded the Two Live Crew. They recorded a bawdy hip hop version of Roy Orbison's Pretty Woman. And that went all the way to the Supreme Court, and Two Live Crew won because they argued it was fair use parody, which we'll get to in a little bit. And they won. So they didn't have to pay or ask permission for anything from the publishers, Acuff Rose publishers. So fair use can be a very powerful tool, especially if you're teaching, working at nonprofits, but that's not a necessary component, but it kind of helps, which we'll go over in the next several slides here. But the important thing to remember is that it's an affirmative defense to a charge of copyright infringement. And what I always tell my students is that I've been asked one question over my 25 plus years of being an entertainment lawyer. It's the question of, well, I'm putting this song in my film, or I'm just gonna not gonna collect money for it or something. It's fair use, right? Well, no one knows it's fair use until you get sued. In other words, it's an affirmative defense, meaning an affirmative defense essentially says, Your Honor, I did it, but I should be forgiven, or my liability should be mitigated. Perfect example of fair use is self-defense. If you hit somebody, kill somebody, whatever, in defense of your person, well, you obviously committed harm to this other person, but you had a justification for it. So you say, well, yeah, I did clobber this, my copyright teacher over the head with a baseball bat, but I had a good reason to do that. And here it is. I'm proving it. I'm going to come forth into the court and prove why I was justified in doing that. So you should forgive me and not send me to jail, and make sure he graduates me in the spring. So fair use comes into play once you do something and the copyright owner decides to sue you for infringement. Now, there's been a little bit of a kink in that system, which I didn't want to get into, but we could talk about it at the end of this presentation, because there's a little bit. The Ninth Circuit, which is Washington, California, Oregon, Alaska, Montana, etc., put a little spin on this, I should say. So we'll talk about that in a minute. But generally speaking, excuse me, fair use is an affirmative defense. So you need to do it first and then say, well, yeah, it was okay because it's fair use. So I just kind of oversaid this, okay? I should said that. Now, there are certain uses that have been recognized as standard fair use, such as teaching, handing out Xerox excerpts from a book chapter. That's part of education. It's an educational goal, and we're going to get into the different goals and purposes in the next slide. But I think we're going to get to this in the second slide coming. Well, I'm just gonna leave it at that right now. So again, if you're a teacher, you make a copy of, if you're teaching guitar, you make a copy of transcript of, I don't know, Stairway to Heaven guitar song for one of your students. Okay, well, you're a teacher, you're educating the student, so that's okay. Now, if I'm going to leave it at that for now and kind of go into a little more detail in a couple of slides. Credit does not equal fair use. Neither is not profiting financially from the use, as I said earlier. But even if you go on, you go on YouTube a lot and you see a little disclaimer at the bottom. I don't own the copyright to this. I'm using it just to, this belongs to copyright to someone else. That's really nice. It doesn't absolve you from infringement. If you have not gotten the proper, permissions and licenses to post a music video on YouTube, you can be liable for takedown or worse. All right, so just telling the world that you don't own the copyright does not mean anything. Intent not to infringe is no bearing on fair use. So again, intention or non-intention, just like in infringement I talked a little bit about earlier, doesn't play into it. If you do something without permission, it could be fair use, but maybe not. So the courts have the copyright law has 4 factors that when you're arguing fair use, a defendant has to prove to the court. I'm going to say 4.5 because there's another one that has been sort of like grafted onto these requirements through case law, like the Pretty Woman case I just spoke about. So the first one is the purpose and character of the use. Okay, that's the first factor. So what are you using the work for? You're going to put it in your, we'll stick to music and film. Are you going to use the song for your documentary, your Greenpeace documentary about saving the whales? Well, that's nonprofit. That could be good. It could work in your favor, but it's not necessary. The Pretty Woman case, which I'll refer to a couple of times through this, was totally for profit because this was a rap group, a popular music group who was trying to sell records. That was for profit use, and they still won their case, all the way, from the Supreme Court, proclaimed its findings on that case. So some of the questions that get asked when this is being litigated is it a straight copy or does it transform the original in some way? We're going to get to that at the very end. That's the one that's kind of been grafted onto the 4 statutory factors by the courts. Is it for educational purposes? Incidental use can be considered fair. For instance, if it's music in the background, if you're going into the squad room in Law and Order or something, and there's a song playing in 2 offices down, well, it's totally incidental, not featured, and so that could be considered fair use. And it's usually not playing for the entire song, which is extremely important, which we'll see on the next couple of slides too. Okay, so the second factor, again, stop me if you have any questions or put it in the chat. I'm keeping my eye on the chat here. The nature of the copyrighted work. Okay, so this refers to the original work that is being copied. So this made up word that everybody uses, copyrightable. It's not, I don't think it's really a word, but the more copyrightable it is, the more protection it receives, and consequently, the higher the bar for defendant. Okay, so what does that mean? So if you remember back a few slides ago, I said that facts and data cannot be copyrighted. So if you're just using someone else's facts and data that they used, and you're just like repeating that and you're using that, well, there's no issue there because you're using something that's not copyrightable. In these slides, I realized this morning, and it was kind of too late to change it, but I haven't talked about the public domain. Now, the public domain, as you might know, refers to copyrighted works that are no longer protected by copyright. The protection is expired, or it was never copyrighted in the first place, or it could be copyrighted, like facts and data. So if you're using in your film, if you're using the Star Spangled Banner, and someone claims, well, you can't use that because I own the copyright. Well, no, because it's public domain at this point, the Star Spangled Banner. Now, here's a good distinction going back to the song and the copyright and the sound recording, distinction. If you use someone else's recording of the Star Spangled Banner, well, you could be, without their permission, well, you could be infringing on the sound recording copyright owner, which then fair use could come into play. But if it's facts and data, if it's public domain, meaning there's no one can lay claim to it, then fair use isn't an issue because use is not an issue. But there is a sliding scale between, usually when I'm live in the classroom, I make a little very badly drawn spectrum kind of, like a sliding scale on the board, on the whiteboard, between those facts and data and between that pure fiction. So between numbers and data, and there's a famous case that is all about phone numbers, for instance, and Lord of the Rings or Star Wars. There's stuff in between that can be copyrighted somewhat, but not totally. Now, music is very important in this regard, and I didn't put this in here. I could add to it because I was trying to keep this brief, but of course, I have to go off on 300 tangents when I mention something, because in the law, it's hard to mention one thing without being, bringing in several other factors. But as musicians, we know that we can go and take our guitars or our keyboards or whatever and play a blues riff, right? 1, 4, 5. Or we can play the famous, what I call them the Axis of Awesome chords, because there's a comedy group, a musical group, kind of made a whole music video about this. But it's the song, it's the chords from Don't Stop Believing. So it's 1, 1, 5, 6, 4. You're all musicians here, you know what that means. If you use those, you can't really, those have been used so much, they become like facts and data. And music is full of those things, full of those elements. Blues riffs, the 1, 5, 6, 4 progression, the 1, 6, 4, 5 progression from every 50 songs has that. If we really had like 2 or 3 hours of time here, I can go into how this has been litigated and diluted, and I'll say one, I'll say 2 words, blurred lines that kind of screw this whole thing up a little bit. But generally speaking, Axis of Awesome, yeah, good, they're great. Yeah, 251, another one. If 251 is not copyrightable, because then every 30s and every Gershwin, Cole Porter song, and Yip Harburg, and they'd all be suiting each other because everybody uses the 2/5 to go into another key, right? So that is that requires analysis from experts and stuff. Well, what is being used here? Is it something that can even be copyrighted? So again, there's this sort of this sliding scale. This is my favorite part of it, I guess, if there's a favorite part, is the court also will look at how much you're taking in terms of quantity and quality. So if you take 15 or, let's say 6 bars, let's say, of a blues song, well, you're not really taking too much because it's probably not copyrightable. But if you take those 4 opening, articulations of Beethoven's Fifth Symphony, which, okay, so let's pretend he's alive and he has copyright, he's copyrighted, he still owns the copyright on that piece. Well, that's pretty substantial, because you're taking 4 notes, 2 notes technically, 4 articulations, that conjure up the entire work. So the amount of substantiality, they don't just look at the amount of bars or notes or, or whatever, but they also look at what is being used by the fair user, the alleged fair user, whether that conjures up the original, which brings to the other thing, the last PowerPoint, the last bullet point here, is that the general rule is that if you're claiming fair use, you can only take what is necessary to get your point across, or to get to reference the original. Now, I give the example here of Xeroxing a book chapter and distributing it to students is probably okay, but doing the same with the entire book might be taking too much and might not qualify you for being fair use. Showing the entire film in my classes, for instance, well, I do it because my argument is that, well, they need to see the entire, film and how it plays out. Like if it's about, music, infringement or hip hop, sampling and stuff like that. But one of the things they do is that they analyze whether you're taking too much, and that leads to the fourth. Oh, here's Cam. I did quote it. Good. Okay, so you guys can read this. The final factor is how the copyrighted, the fair use, whether or not it, and how much it affects the market value of the original version. So I mentioned this case already, Pretty Woman. In that case, the court looked at these two tunes, the original and this bawdy, very risque hip hop version, which used the famous opening, that they use that, because that's how you conjure up Pretty Woman, pretty much, is one of the most famous intros and interludes in pop music. But then they kind of went off on their own and changed the lyrics and everything like that. If they had just they just copied the entire song and released that, well, that's something different that usually takes you out of the realm of fair use, because now you're just creating a copy. And there are other ways to do that without seeking permission, which we're not, we can mention it if we have time. But essentially, the court looks at how much did the fair user take? Is it too much? And will it displace the value of the original in the marketplace? So again, if you're going back to the Xeroxing the entire book, well, if you're handing out Xerox versions of the entire book for free to your students, well, think of all the book sales that the author and the publisher are missing out on. So that's a very substantial, to use another word I just used, very, very significant factor in determining whether fair use applies. So this is the one that I said is kind of been superimposed upon the 4 factors. Again, those are found in the copyright law section 107. If you want to copyright.gov, I should put, maybe I'll put that down at the bottom here. But it's if you're interested in the copyright law, that's the official government website. That's where you register work, but there's also tons of information about development. You can the entire law is there. There are flyers, they're called circulars, that explain stuff like fair use and other elements. But related to the fact that if you're using too much, you might not get fair use. There's a concept in the copyright law called a derivative work, which essentially says you're creating a new work based on a pre-existing work. So let's go back to the Star Spangled Banner. If I create a hip hop version of the Star Spangled Banner, well, I'm taking the original, which happens to be public domain, and creating my own work, which is now a copyrighted work because it's original. Now, if you're making a derivative work on a song, we'll stick to songs that someone owns the copyright to, well, then you cannot make that derivative work without asking permission. If you harken back to one of the first slides in this, and we can go back to it, that's one of the powers of the copyright owner, to prepare derivative works, and you can only give that power to someone if they, if you so choose. And a derivative work is often called a transformative work, meaning that it transforms the original into something new and interesting and new and bright and new and lovely. So in the Pretty Woman case again, and this is from that case right here, this quote, it's not really a requirement, but you have a better chance of winning your case, of emerging the victor, if you create something new, which the listener or the court will say, yeah, okay, well, they did something new and a new copyright work, and that's pretty good. They don't care if it's good or not. They just think if it's original enough. And that is a factor that goes in favor of your winning your fair use argument. Final one is just, again, this is the big thing. I probably should have done the entire presentation on this, is YouTube and social media, using stuff on YouTube and social media. In some ways, I could spend another hour on this, but in other ways, it's very simple. Don't do it without seeking permission. And if you're streaming something, YouTube, we'll stick to YouTube for now because that's the most, that's the ocean of infringement or potential infringement. They have licenses in place with the performance rights organizations, ASCAP, BMI, and CSAC, and a couple others that exist now, GMR. But if you're putting up a music video, if you're putting up something from a Seinfeld episode or a clip from Star Wars, or redubbing something from a movie, well, you're creating a derivative work. Plus, if you're just using a straight music video and you're doing a cover tune, let's say of Stairway to Heaven, we mentioned that earlier, you require a synchronization license, because as soon as you put music to moving images, you're creating an audio visual work, and that is a power that remains with the copyright owner to allow others to do that and do it themselves. So again, YouTube is a big thing. There are laws that apply to this. There are lots of new developments over the last few years that, maybe the next time I can do that, because it's a little complicated. But essentially is like anything else, don't do it if you can't ask permission, or if you don't have permission, don't put it up there, because you will either get it, get a takedown notice, which YouTube says, please take this down, or you'll be asked to monetize it if the rights holder decides, well, you can leave it up as long as I get paid for it, which is why you see those annoying ads when you want to look at something and they have, you watch the whole 30 seconds, or little pop-ups come at the bottom of the screen or something like that. So that's the general rule. You need to ask permission, or else you could be, we've been streaming, ensembles at the end of the year for concerts are streaming now a lot. And a lot of my colleagues have been complaining that, they've been taken down because, YouTube now has an algorithm that recognizes copyrighted works that are being used without permission. So it's a minefield. And again, if you want any more questions, this is the last thing, and I really sped through this. So let's ask some questions, but I'll leave it up. I'll just keep sharing in case we want to go back. I'm out of breath. That's about as quick as I've done it. So, okay. So let's see. Okay, so so this is plenty of tutorials as well. So like how to play, you could argue, since you're sort of, because they're all over YouTube, obviously. There's that one guy that has a lot of the greatest guitar solos of all time, and the greatest piano intros, and
Rick Beto.
Yeah, Beto. So I'm gonna guess, because he's been up and running for a long time, that he has permissions in place somehow.
And he's had some issues too over random songs coming in and grabbing from different copyright holders, it seems like. But when I was wondering, when you're tearing songs apart and you're like, oh, here's how to play the solo to this song or whatever, and you're not actually using it, would that fall under fair use?
Well, I would say, if I was your lawyer, I would say yes, that's fair use, because you're educating the public, you're educating your students, and you're not using the whole thing. You're just piecing it together, and you're creating a lesson.
Okay.
It's sort of similar as posting a book review or an album review. You're not going to play the if you're the book reviewer for the Seattle Times, you're not going to just copy the entire book. You're going to say, well, it's first chapter, J.K. Rowling says this, but it conflicts with this in 10 chapters later, and you put that little excerpt. That's fine. That's education, and that's using little bits. So I think tutorials, you should be, you should be fine, but always be prepared to be taken down.
Yeah. Because for a lot of us, that's a way we kind of market our businesses, is we'll do tutorials. And that's a way to get your name out there and create organic traffic.
Right.
And, every once in a while, for every 10 I do, I'll have one that'll have a copyright. Maybe I'll play too much of it and the algorithm will hear it maybe, or something, or,
yeah. And again,
I always wonder what the rhyme or reason was to it.
Well, there is no rhyme or reason. It's in my experience. It seems like, if someone wants to make a complaint, they can,
right.
But I think that's a pretty good fair use. Now, there's a big fair use, case that went on that, I was going to mention it in the slides, but if we have a few minutes at the end, I will talk about it. It has to do with Prince and Let's Go Crazy.
Whoa. Okay.
Um,
Well,
I have
thank
a
you so
question.
much.
Yeah, so we'll talk about that in a second, but let me just get a couple of these questions. Okay, so Marguerite, you have a question? Okay.
Yeah, I had a question about YouTube. So occasionally I'll have a recital with my students or whatever, and I usually video the recitals, and I have permission from the parents of the students to, if I wanted to use their performance of that. So if a kid is playing a piece of music, regardless of whether it's public domain, if they're playing a Bach piece and it's public domain, great. But if they're playing for their recital a copyrighted piece of music, and technically it is a public performance of that music, right?
Well,
So does a teacher need to have a copyright or a blanket copyright for use of?
okay, so that's related to what Sandra asked about
Okay.
handle videos of student recitals which are posted unlisted to YouTube.
Or listed. I mean, now that I think about it, I've never posted a student recital publicly on YouTube, but I am curious about whether that makes any difference.
If you are, well, you're probably a little bit safer. You're a little bit like in the foxhole maybe by doing it unlisted, but they will still, the algorithms still like pop up, because we've had that problem as well at my school, is that, they'll post a live stream. So usually we've been posting videos. Videos are the worst because they're like memorialized forever. And so they're up there. So, it's open to content ID, disputes. Streaming, if it's not archived, which unfortunately YouTube archives them, you could get away from that from a performance level. But again, there's the whole sync licensing. As soon as you have moving images with music, you're creating an audiovisual work, which has nothing to do with the PROs, which, ASCAP, et cetera. And that's where the problem lies, because they will say, well, you need a sync license for doing this. Now, if it's Bach or something, or, something, from the classic repertoire, you're fine.
But what if it's a Beatles tune or something?
If it's a Beatles tune, or let's see,
Or something that's
Karen,
currently
I've been
copyrighted.
playing some classical music by Poulenc, which will be distributed to the grade schools. I use the score, recopying. Okay, so if you are distributing your own version of an entire piece by Poulenc, you probably should get permission from the publisher, because you're basically telling them that, okay, I'm going to give this away to my students for free, so they're not going to buy your version. Poulenc is dead, right? So is the state, as publishers.
Okay, so what if when I provide music to my students, I usually will purchase it, like from a service like
Right.
Music Notes or something. So I'll purchase, and it clearly says on it, licensed to blah, blah, myself.
Right.
But then if I hand that to my student to use to play that version of that,
No, you're
published-
fine. You're fine.
Okay, but then am I fine if it gets posted to YouTube? Is what I'm.
No. That's
Okay.
that's when you start running into problem, because
Okay.
giving it to your student, well, this is a classroom situation. You're teaching them how to play the tune. Here it is. Putting it on YouTube distributes it to the world, and
Right.
distribution is something that the publisher takes very seriously and guards with their lives, basically.
What if they do that? What if their parent does that? Is that also
Then they're in trouble. They could be in trouble.
okay?
Yeah,
That's a good
so-
thing to let parents know. Then. I
Yeah,
think.
you just got to be careful when you're posting stuff to YouTube and it looks cute.
Yeah.
It's okay. So it's a good time to, like, a few minutes. We have about 8 minutes or so. So a few years ago, I'm going to say 5, 6 years ago at this point, maybe, a woman posted on YouTube her toddler dancing to Prince's "Let's Go Crazy." It was 27 seconds of the song. Now, the algorithms for YouTube weren't as robust back then. So if you wanted to find out if your works were being posted on YouTube without your permission, you kind of had to monitor it yourself. So Prince, of course, being Prince, had like a team of people doing that, going through like, the 10 billion videos that pop up on YouTube every day, get uploaded. Found this, sued the woman. All right. Because it was only 27 seconds and they said, you didn't have permission. She argued fair use. They went back and forth. I think it eventually settled. But her argument was that it was fair use and that she's okay to do it because it's just comedy. It's showing, there's always you have to have a justification for it, basically. When she got sued, now, regardless of how the outcome was, that was the case I said that put a little spin on this whole affirmative defense thing, because that case, the Ninth Circuit, which is the appellate court that services like California, Washington, et cetera, it's a very important appellate court, obviously, because it encompasses LA, which is like the center of the music industry. So when the Ninth Circuit speaks, sort of everybody listens. They don't need to necessarily follow it if they're in the Second Circuit. But what they said is that, okay, if someone's going to ask you to take down a video from YouTube, they have to have conduct a good faith inquiry onto whether the poster could argue fair use, which is kind of a weird thing that they kind of shifted it from a totally affirmative defense to now, well, you have to think about whether this is fair use or not. But that's a nuance that we don't need to worry about right now, I don't think, because the general rule is still post it without permission, you can get in trouble and you can get it. Again, we've had stuff. One of our ensembles was live streaming, an end of the year concert just last week, and it got flagged and it interrupted the stream and stopped the stream. What they did do is record it and put it on their own website, like the ensemble's like private website. Having a private YouTube channel could kind of prevent you getting in trouble. Because it's private, then that assumes that it's not being distributed to the entire universe, that only people who are invited in. It's like if you're showing a film in your house to your friends, you can't get in trouble for that because it's private. It's not a public display or performance. I'm just going to stop the share here, so we're not going to go back to this now.
I had one other question, unless somebody else had one. In terms of the public performance, like the recital itself, and that
Right.
kid, not the video now, but the kid doing the public performance for a limited people, just the people, parents, students, in a situation like that, is that still considered a public performance? And should the studio have a blanket license?
Well, I don't think that the studio should have a blanket license because, again, you're not, public performances really are meant to cover performances that anybody can go see.
Mm-hmm. Okay.
So in my past exams and quizzes and stuff, I gave, I don't give multiple choice often, but one of the multiple choices I gave at one point was like, decide which of these is a public performance for purposes of the shower, humming a tune in the shower at 24 Hour Fitness. One was, playing a film at in a hotel room for a bachelor party, and the other one was like using it as a I don't know what I used exactly, but it was something like, playing it at a political rally, let's say at let's just say the Kingdom. There I go. See, I still miss the Kingdom. So if it's in a place where like it's really going to the public, of course, if it's broadcast like on the radio or anything like that, that's a done deal. But if it's like your parents, like, we have student recitals all the time at our school, and we happen to have a blanket license with the PROs because we're a university. But it's basically, like I said, it's friends, family, teachers. It's not like anybody can just kind of go in. It's not, and that's why streaming it at that point or posting it on YouTube takes it out of that private performance into a public performance, and not public performance just for the music, but a public distribution of an audiovisual version that uses that music. Again, I told you at the beginning, this is going to sound scary, some of the stuff I say. The unofficial advice I get, it's not really advice, it's just sort of like, I don't know, if anybody remembers a guy named Richard Nixon, he had a famous quote was that his biggest crime was that he got caught or something like that. You know, that was like one of his quotes. So, you know, I never tell people don't do this or else, you know, you're gonna like you'll burn in hell for eternity. Um, it's all a risk taking, you know, it's a risk benefit analysis. Well, if I put this on, you know, YouTube for, you know, a limited amount of time, let's say, and just on my private channel, let me just try that. And, you know, the thing is, you're not going to go, fortunately, you don't go from like posting Poulenc or the Beatles or whatever to the courtroom. Usually there's steps in between, like a takedown notice or an interruption of the stream. So that happens, you kind of figure out, well, what's the next best thing? Now, the streaming is a kind of a pain because it's live and people are watching it. And I think that's probably easier to get away with if you're streaming it once, but once it gets archived and people can review it, you know, rewatch it, that's when it becomes a problem. I think a one-time, you know, ephemeral stream, as they call it, because it's not, you know, it's not, you know, recorded and set in stone for eternity. That's probably an easier thing to do. But once it gets recorded and archived, and YouTube does it automatically, which, you know, it's kind of a pain. So you just have to be careful. Again, the best thing is to get permission. If you can't get permission, then just there's a couple of works around. Yeah, and you just got to kind of just be willing to take a risk. And again, the worst thing that'll happen is it'll be taken down. Hopefully, you don't, you know, people aren't like Prince will pounce. The person took it down to put it up again is what happened. This woman. Let me just look through the chat here. Public domain, you can do whatever the hell you want with it. So who asked? That was Ryan. Okay. Yeah, like I said earlier, public domain is up for grabs for the entire universe to use.
To be clear, what I am asking about is if I have, let's say, a Henley edition of some urtext printing, and there's some part of something in there that I want to send to a student, does that in any way violate the Henley publishing copyright?
Well, if you're just sending a portion of it to a student, no, you should be fine, because again, you could just, I don't want to make it sound like, you know, you guys are all teaching students, you know, you can disseminate pieces. I mean, you're not gonna get thrown in jail or anything like that. It's part of education. That's part of a fair use, you know, regime, if you will. So yeah, you're fine with that. It's when you start going beyond the classroom, basically. So, okay, so like I said, I show films in my class, you know, and they're for my students. And yeah, I could get in trouble, but you know, my argument is that they're necessary. The whole film is necessary so they can learn the lesson. We just watched one recently. Well, I watched it over Zoom, which I'm really not supposed to do. But if I took a film, this was a film. It's about it's about 30 Seconds to Mars. They get sued by the record label. It's called Artifact. If you ever get a chance to look at it, it's fascinating and see how what a horrible world the record industry is. If I took that to the main auditorium on campus and just like showed it to, you know, tonight showing Artifact, well, that's a different story. Because now I'm letting everybody in, and now it's like, whoa, you need permission for that. So if I copy one piece of music okay. Yeah, if you're doing it just for your students, let me make that clear again. If you can copy whatever you want for your students. I mean, copying like an entire folio, you know, yeah, that's probably not okay, but again, who's going to know? But, you know, you run into problems when you start, like I said, disseminating it to the world. And that's the problem with YouTube, is that anybody can get on YouTube. Now, if you have a private channel, you could at least make the argument that, well, it's only for people that I choose to watch, you know, to allow watch this. So, but just like posting something on YouTube for the entire world to see could be a problem. And, you know, when I say it could be a problem, somebody has to complain about it. You know, if, you know, okay, so here's an example. My daughter, when she was in high school, she was in a chamber, you know, a string quartet. And for the graduation, they did a string arrangement of Baba O'Reilly by The Who, which she and I arranged, and I helped her arrange it. And that's still on YouTube. No, The Who have not, Pete Towns has not, asked me to take it down as far as I know. So someone has to complain, But a lot of people are more, and YouTube now has these algorithms. If you post it, they're going to say, "Oh, well, there's Bob O'Reilly." Maybe this was pre-algorithm, probably. Yeah. Okay. So Karen, before you ask Margarita, let me just Karen. No, it does not matter if it's free or for money. If you're using something without permission, it's infringement or it's potential infringement. I don't want to say it's infringement because that's for a court to decide. But yeah, again, I stated that earlier, money has nothing to do with it. Because if you're using something without permission, then someone can make us think about it. Now, whether they're going to get money after they sue you, if it's for free, that's a different story, because that's the damages phase. The copyright infringements always have two phases, two steps. Sort of like a criminal case where you decide whether the person's guilty or not guilty. And then you have sentencing. Copyright's the same thing, and most civil litigation's the same thing. Sometimes they're in the same trial, but oftentimes they are separated. So you have a trial that determines whether the defendant has violated the plaintiff's copyright. And then you have another phase which says, okay, now that you've lost, defendant, if you've won, well, if you haven't violated, then end of story. But if you have violated the plaintiff's copyright, the next part of the trial will be, well, how much do you owe them, or what damages? Do you have to take your CD off the market? Do you have to pay them your lost profits? Blah, 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 blah. So, but for the actual liability part, money has nothing to do with it. I saw something in here that I want to, such performances are done for free and never the, okay. What about performing video typically on a website on YouTube, closing music from the edition like Henley, which is copyright, music and stuff like that. Yes, the reason why publishers like Shermer and Henley can stay in business because they do copyright their editions. Now it could be just the way the phrasing is done, or like the articulations, or the fermatas and all this other stuff. But it's publishers of classical works which are not copyrighted have a copyright in that printed edition because that's their edition, that's their arrangement. It's an arrangement copyright, which are perfectly, that's people do that. So if it's the public domain, it doesn't matter which publisher one is reading the score from. Again, it all has to do about disseminating these pieces. If you're reading it or if you're conducting from it, well, that's fine. And a lot of times when you buy like student, I did a lot of church playing, in my life, and you buy church music and it often has a license to copy for the choir members or something, so the thing about copyright is that the copyright owner holds the cards. And if they decide they're doing something that displeases them, then they have every right to come down on you. It's just that a lot of times they don't care. There's plenty of stuff on YouTube that, people, okay, well, it's up there, who cares? Sometimes they look at it, it's free. If I were Pulak, I'd say, well, this is great. This is free publicity. No one listens to Pulak anymore, right? I mean, lay people anyway, right? So that's an attitude that it's their choice to make that attitude. So I've confused everybody and scared everybody, right? So, Margaret, you had another question, right?
Yeah. Just one more, and I know our time is getting nigh here. There was a situation where CD Baby put out a thing to its artists that basically it didn't ask permission to put the works that they had from artists on YouTube. They just went ahead and did it, but they did send a notice and said, if you don't respond to this, we're assuming it's okay. And I was one of those artists, but I have some other, some students too who were also on there. So what is the situation like that? They just, don't they have to get some sort of agreement to be able to post something? I had him take mine down because I didn't want my stuff represented just with the album cover and the music,
Right. So I have stuff on CD Baby. I forget what their agreement, the license agreement is all about, but it may say that in the fine print. You go with CD Baby, and we can disseminate your music as we see fit. If that's in the agreement that you sign with them, then they have the power to do that. If it's not, then they should ask permission. But I kind of think, I don't really do anything with my music in there, but I'm thinking it's probably in there because I don't think they would take that risk because they've been, they're pretty savvy, been around for a long time. Because also CD Baby has these different levels. You could sign up for just like, selling your own stuff. You can sign up for like putting it on iTunes and all this other crazy stuff. So, so it really, I can't believe I did not say these two words here today, because it is the two words that is sort of the hallmark of my teaching, that it becomes a joke with my students, but it depends, because everything depends in the law, what you agree to, what what your uses are for when we're talking about like fair use. It could be, I can't, give you any blanket statements, even though it sounds like I'm giving you blanket statements. Get permission. Well, yeah, you should get permission, but sometimes you can't. Sometimes you don't know who to get permission from. You do it, and then you find out very quickly, perhaps, who the owner of the copyright owner is. So yeah, the CD Baby thing, I'm guessing that might be in the fine print somewhere, that they can, once you sign for the certain level, you allow us to do whatever you want with your stuff, because that's they do. They put it on, they put it on Spotify and everything. So maybe, now that I'm thinking back, I think YouTube might be in that collection of that litany of social media and websites that you give them permission to distribute to. I should look it up. Yeah. So who didn't I scare here today? I mean, I hate to do that, but lawyers, we like to make it sound like the world's coming to an end. Again, you guys are all teaching. You're the essence of what fair use is all about, the essence of what educational and nonprofit purposes are all about. You just got to be careful when you're like disseminating stuff where everybody else can see it. So doing stuff for your students, you're totally good. There's absolutely no problem with that. The only problem, again, is when you start inviting the rest of the world to see what you're doing and see what your students are playing. Again, you're fine with the, with the classics, with the standard, classic repertoire. Anything previous to about 1928, I think, is the cutoff date this year, is in the public domain, because it couldn't possibly be under copyright, even with all the previously, there's an incredible labyrinth of renewal periods, all this other stuff. There's no renewal for the current copyright law, which, by the way, is life of the author plus 70 years. And for more than two people, more than one person, is the life of the last surviving author plus 70 years. Now, for companies, when you transfer your copyright to a company, that's a different story, but let's not worry about that right now. But yeah, so if you write something today, it's yours. Even if you don't use it, even if you put it in your sock drawer until you pass away, and in your 69 years and 6 months after that, your successors find it, well, they have 6 months to exploit it. After that, it goes into the public domain. And that's kind of relatively, well, not new. It's in the 90s that Life Plus 70 came into. Yeah. So again, just be careful. Remember the old Hill Street Blues TV show? Some of you maybe. They always they would open up in the squad room, and the sergeant giving the daily assignments and stuff, and it'd always end with, before the credit music, be careful, it's digital. It'd be fair. Be careful out there. Well, that's what I say. Be careful out there, because there's a lot of it wasn't like this 40 years ago, 30 years ago. When we didn't have all this wacky dissemination and ability to just download, copyrighted music without the person knowing it. I mean, even you mentioned I forget what one of the services you mentioned, Margarita, but there's a lot of illegal, like, sheet music being, you download for free. Well, that's illegal, really, to download sheet music for free, because that means they're putting it up there for free and not compensating the publisher. So it's a crazy world we live in. But as I mentioned to Ryan in a chat here, Margarita or Mariah or somebody is going to disseminate this PowerPoint, so you can do what you want with it. You could, line your litter box with it if you print it out. But my name and email are on there. So any questions, I welcome any questions. Yeah, music notes. Well, if I don't want to see you guys in jail, because there is, most copyright infringement is civil, but there is something called exists of criminal copyright infringement. So, you go to the movies and, you see that big thing, or even on DVDs now or on Netflix, that thing that stays on the screen for like, 58 seconds or something. It's like, FBI with the FBI logo. It's like, don't, copy this, or $250,000. Well, that's true. They could do that, but criminal copyright infringement usually comes into play when we're talking about like big blockbuster movies or like Rolex watches and stuff that has a lot of high market value. But it's still available if it's big enough for the feds to get involved, they will get involved. But yeah, ask me any questions. Feel free. Don't be afraid. Again, I understand what a minefield this could be. Again, Margarita spent 20 minutes on my background, which I can't believe I sent you that. But I'm a musician, so I know how you guys think, and how to make you, hopefully make you feel better with like what you're doing and stuff like that without, so just let me know. Any questions? I'm here.
I have a question if you still have time.
Yeah,
Just copyright for dummies question, because you probably already addressed it, but I just need a summary. Yesterday, I asked a student to download from Jay Unger's website and pay for Ashokan Farewell, which is a popular fiddle tune that was used in the PBS series on the Civil War. And so I'd like her to play it on a recital. And I'm wondering, this is over Zoom. It's going to be over Zoom. Then I post those recitals unlisted to YouTube. Theoretically or practically, do I need to get separate permission from Jay Unger for her to perform it in public, so to speak?
Okay, so is it the Jay, write the tune, or is it like a traditional Civil War era?
He wrote the tune almost 40 years ago, but I mean, it's his tune, but a lot of people don't understand that. It sounds very traditional. It was used in the Civil War series, but I mean, I know what it is, and I have the printed edition already. I actually bought a copy of the download myself yesterday, just so I had that version, and my student, I hope, is doing the same. But my question is then, if she's performing it on a recital, is that a separate copyright issue?
Okay, so if you're performing it just in the recital, just like I said earlier, Beth, for friends and family and stuff, you're good to go. It's only when you start posting it on YouTube that now, because this Jay person is like, well, my music's now out there and someone's playing it and I'm not getting paid. And I didn't get permission to do that. So, and again, YouTube has a mechanism for that. Maybe he, has an account with YouTube where you'll get the little, it'll be flagged and it'll say like, you can monetize this for Jay, or you need to take it down.
But if it's unlisted, that probably isn't a problem. Am I correct about that?
We've been running into this problem for, with our, like I said, with our school. And my thoughts are that it's easier to get away with. I'm not sure if, because I've read a lot about their YouTube policy and stuff like that, and they're not like totally like clear whether it's unlisted, because they could still, they're still looking at it. It may be unlisted, but they're still looking at it. And the reason the reason why YouTube might want to like say something is because they don't want to be held liable. Okay, so just real quickly in 30 seconds, the 30-second version of the Digital Millennium Copyright Act, which gave a safe harbor to YouTube and other internet platforms, web platforms, to be absolved from liability unless they know that there's some infringing activity going on. So they kind of have, if they find out, and this is why they developed, when that, in 1997, when that law came into effect, they didn't have all these like algorithms. Now you can put something up and they immediately, identify something as being, infringing or possibly infringing.
Okay, one more follow-up question, if I may. What
Yeah.
if we put together a compilation of excerpts from recitals, from student recitals, made a new video of it, and it's a few seconds of Ashokan Farewell and some Bach and some this and whatever. Is there and then I wanted to post that publicly as a marketing device for my studio. Am I going to run into problems having a few seconds of a copyrighted work being performed by a student?
The short answer is yes, because again, I'm scaring everybody. Just think of sampling. If you put out a record that has a 3-second sample of another song, well, now the publisher, and if you're using the actual like record, the label can come after you and say, no, we need to be paid for that. That's why there's now sample clearing companies that you can pay them a fee and they will clear all the samples for you that you put in the song. So this is like sampling basically. And again, it's audio visual, so that's a whole nother component when you're, again, anytime you're creating something on YouTube, you're creating an audio visual work, which has nothing to do with sync licenses. I mean, nothing to do with like mechanical licenses, the permissions, as far as the music goes. It has to do with the music, with the film, with the visuals, and that's a synchronization. And when you piece together different, like 3 seconds here, 5 seconds here, you're creating a derivative work of that piece. So 3 seconds of Jay's, fiddle piece, interspersed with 5 seconds of, air on the G string and 6 seconds of Rite of Spring or whatever. You're now creating a derivative work, which is a power that definitely belongs to the copyright owner. So again, if you're putting it in public, just be careful, because if you start posting, and again, most of this stuff on YouTube they get away with murder. I still don't know how, but you just got to be prepared to kind of take it out of the, the other thing, why use it? If it's going to cause trouble, why use the, that particular piece? Just use old standards. It's still giving you an advertisement for your studio, but you're safe. You're totally safe. You're using Bach and, Mozart and everything. You're completely safe, because you're just doing performances of public domain works. No issues with that.
Sorry. No, sorry.
Is it okay if I ask a quick question? And this may
Sure.
be beyond the scope, but I am working on a patent for something music related, and I talked with a patent lawyer. We discussed things. He wanted me to send me the material. Then he wanted me to do the write-up of how it all is used. And I said, shouldn't we have a contract or something like this at this point? But he also scared me because he says, oh, I can do everything with Adobe. I can manipulate anything I want with Adobe Photo. And so I'm just thinking, at what point do you sign contracts with lawyers for this process of patenting something?
Well, in my case, probably never, because I've done so much free work for my early days when I was really practicing. But no, seriously, if the lawyer is doing any work for you, again, anything you ask me to do, don't worry about money, unless I have to go to court or something like that. But if you're sending me questions and stuff, I'm happy to do it for free, and don't even think about that. But if you're engaging a patent lawyer, for instance, and for me to tell you how to copyright a song take 10 minutes. For a patent lawyer to do a patent takes about a year, because it is an extremely involved process. I mean, maybe give or take, I don't know even exactly, but it's extremely long, it's extremely expensive. So my answer to you is that he has to give you a fee agreement like immediately.
Okay, so he's already done research. We've already had a lot of discussion. He's already worked a lot, and yet I've never paid him. I've asked him about a contract. So that seems like red flag, right? So we
Well,
should have,
it's a red flag, except the fact that he can't come back and tell you now, well, now you owe me $5,000, because he's bound by the Washington State, Bar Association and the rules of ethics, the rules of lawyer conduct, that he has to disclose his fees to you if he's doing any work. Now, if he said to you, I'll do this for free, then okay. Just like I just said, you want to ask me any questions about copyright or just fair use, freebies. If I have to start like negotiating contracts or something, that's different, obviously. But yeah, so, you could do two things. You could say, let him do what he wants to do for free. But I wouldn't recommend that. I'd say, listen, you should say, or ask him, you've done all this work. When do you want to start talking about a fee agreement? Because he needs to give you a fee agreement before any money changes. And that's required under the canons of ethics in our state, in most states, pretty much, but definitely in Washington State. I know that.
thank
But
you.
yeah,
Thank
I would just like, don't, again, you could just say, enjoy the cake while it's being given to you for free. But if he comes back and says, okay, well, I did all this research, I filed it with the patent office, the filing fee was $5,000, $2,500 or whatever. It's like, well, you didn't tell me you were going to charge me anything. So he's out of luck. But you don't want to, because then you start, going into court and stuff. I would just, bring it up and say, are you going to send me a fee agreement for this stuff, or are you doing it for free? Ask him, is this pro bono?
And I just wanted to interrupt, Jeffrey. You've been very generous with your time today, and I know we've gone over quite a bit. So I just wanted to say maybe people can follow up any other questions, with you online. And
Yeah, definitely. But let me just say, Carrie, and I was going to say that, actually, I forgot to say it, that, yeah, the big thing about, signing a fee agreement is that you want to make sure this guy doesn't, or woman, whoever it is, doesn't like run off with your idea. And now that he's patenting it. All right. So, because part of in a patent agreement has to be like everything is confidential between, and, he's bound by confidentiality as it, just by being virtue of being a member of the bar. But that has to be made clear as well, because that's somebody once asked me, says, I don't want to disclose this stuff to a lawyer because they could just steal. I said, well, then, yeah, they could, but then they're going to get in a lot of trouble if they steal your, because they're supposed to be confidential and he's working for you. But that's why you need to sit down and work out the fine details of what his jobs are. Is he going to do the filing? Is he going to here's a question. I'm sorry. This is, we could talk offline, but is he a certified or registered patent lawyer, or is he just, okay, because that's a big deal too, because some people say, I can do a patent, but you actually have to be a member of the patent bar to be able to do patent law, because it's a very complicated, I'm not, because I don't have you have to have a computer or biological or scientific background, because it's all about inventions and formulas and all that stuff that none of us really want to listen to when we were being taught it. Math.
Awesome. All right, people, we've gone over our meeting time. So that was an amazing presentation, Jeffrey. Thank you.
I'm sorry. I always talk too much anyway. But...
No. This is amazing.
So much.
I thought very, very valuable.
All right. So just, again, everybody,
Yeah.
just let me know if you have any questions. Margarita, I guess you have the copy of the PowerPoint. You can just send it to everybody.
Okay. Yeah, I think
just let me know.
Mariah does actually.
Yeah. Okay.
She's got the master list. So
Cool. All right.
and I'll hand it back to Katie if
Good to talk to everybody. Thank you so much for listening, and I hope to hear from you guys. All right. Take care.
Thank
Thanks
you.
so much.
Have a good
Take
summer.
care. Yay.
It was
Yay.
very informative.